I'm going to talk about today is three decisions that came down from the Supreme Court of the United States in June, this past June, a month or so ago. Two of which, Buckley's already getting after me. I'm going to throw this thing at you. Two of which I'm sure everybody's heard of. A lot of media attention. One of them was the King v. Burwell case, which was the Supreme Court's third run at rewriting the Obamacare Act. Now, it wasn't good enough that Obama rewrote the thing as the executive president of the country, exerting his legislative executive powers. But now we got the Supreme Court weighing in and virtually rewriting it three times. And then the other case that you would have heard about was the Obergefell case, which was Obergefell v. Hodges, which dealt with the gay marriage issue. And the Supreme Court came down with a decision that got a lot of pulses beating and got a lot of criticism and got a lot of press. The first case that I'm going to talk about is, however, one that maybe you hadn't heard about. I locked onto it because it deals with kind of my pet provision in the U.S. Constitution, which is the Second Amendment. This is a case called Jackson v. City and County of San Francisco. And this really wasn't a Supreme Court decision. This was a case that was decided in a district court for the Northern District of California, went to the Ninth Circuit, and then it was appealed to the U.S. Supreme Court. Now you can imagine when I say the words Ninth Circuit, what kind of decision we got on the Ninth Circuit on a gun case. We got one good decision in the last 2 decades from the Ninth Circuit, and that's being taken up en banc with the whole Ninth Circuit. I expect them, that's the Peruta case, I expect them to overturn that because that was a case that really was constitutionally valid, and the Ninth Circuit doesn't like any case that's constitutionally valid, that's supported by the language of the Constitution. So, but this Jackson case goes up on a Ninth Circuit decision to the Supreme Court, and the Supreme Court denies cert, which means they refuse to review it. And what was interesting about this is that happens all the time. I don't know what the numbers are, but the Supreme Court gets thousands of cases presented to us on certiorari, petition for certiorari, every year. And they deny a lot of them. And, you know, they write a one-sentence deal, cert denied, and the litigants go about their way. They're at the end of the game, right? The Supreme Court is the top court in the land. Well, in this case, it's a little different. In the Jackson case, because Justice Scalia, joined by Justice Thomas, wrote a scathing dissent, a dissent of a denial of certiorari, and took him to task. So we're going to talk a little about that. And we're going to talk a little about the decisions, about the logic behind those decisions, how the court got to the decisions, and what those decisions mean to you and me today. Before we get to that, let's talk about something that maybe we don't get in the media, and that is how the court, what kind of philosophy, what kind of how they come to the decision when they're interpreting the Constitution. that's something that you never hear about. All you hear about is, yeah, it's a good decision. No, it's a bad decision. Oh, they violated the Constitution. But the media never puts any bones on that. That's because most of them wouldn't know where the bones are or any meat on those bones. Most of the media wouldn't know where the meat is. So we're going to talk a little bit about constitutional interpretation. Here's what President Ronald Reagan said about it. Judges should not be liberal or conservative because the Constitution is not liberal or conservative. True statement, right? Should be a true statement. I'm not sure it is anymore. Something that we ought to probably think about a little bit too is where these Supreme Court justices get their power, where they get their authority. Anyone tell me? You got it. Article 3 lays out the power and authority, the jurisdictional power and authority of the Supreme Court. What Article 3 says is, in part, what the Supreme Court is entitled, has the power or jurisdiction to hear, is all cases arising out of the Constitution, federal laws, and treaties. Well, of those three bodies of law, the Constitution, again, is what? Supreme law of the land. That comes from Article 6 of the Constitution. Now, here's something else to think about. So these Supreme Court justices, these 9 lawyers that we dress up in black robes and put them in the Supreme Court building in Washington, D.C., these 9 guys have limited powers. They can only do so much under what we just talked about, Article 3, which lays out the limitations. And then there's an old case, and I can't remember the date, but it's way back when I was very, very young. It was way before me, called Marbury versus Madison, where Chief Justice Marshall made very clear that the Supreme Court also had the right, as part of this addressing cases arising out of the Constitution, for something he called judicial review. So they had the right to look at legislative acts and other laws and determine whether those laws were consistent and supported by the Constitution. So that's their power. Something else to remember is that Bucky could tell me how I get a drink of water and speak into this thing. I'd appreciate it. Something else that I don't think a lot of people understand. You know, the Supreme Court justices take 2 oaths to be able to sit in their Supreme Court, at the Supreme Court bench. They take an oath under Article 6. And that oath is to Clause 3. And that oath says that they take an oath to support the Constitution. Makes sense, right? They're up there deciding cases arising out of the Constitution. They take an oath to support the Constitution. Then there's a federal law that requires them, it's a federal law that requires them to support and defend the Constitution. And then it goes further, and it says to bear true faith and allegiance to the same. Remember those words as we go through these cases. Bear true faith and allegiance. And let's talk about that as we go through these cases and see if they're shouldering their oath, if they're doing what they swore they would do when they took office. So let's talk about constitutional interpretation. These theories of constitutional interpretation are really the methodology that the court uses to interpret provisions of the Constitution and for that matter, provisions of federal law when they're at issue in front of the Supreme Court. Sometimes their job is this. Their job is to take the law, these judges, they take the law, they apply them to the facts to get their decision. Law applied to the facts of the case, get their decision. But sometimes the law is not so clear, especially legislative laws. Anybody tried to read a piece of state legislation and figure it out, some of them are indecipherable. Who studied English? Any English majors here? That figures nobody's stupid enough but me. There's a I think he's a 19th century poet called T.S. Eliot. If you can understand T.S. Eliot, you might not be able to understand some of the legislation that comes out of our state house. When I went to law school or was about to go to law school, I was trying to figure in the undergraduate area what courses to study. I was a little older. I had a family started. I couldn't afford to screw up. So I'd go to the counselors. I went to the counselor at U of A. I went to the counselor at ASU. I went to the counselor at UNM. And I asked them all, my intent is to go to law school. What should I take? And they all said, it was like they had it programmed. Oh, don't worry about that, Don. Take something that you enjoy. Just have a good time. And I thought, wow. And I finally went to a lawyer because I had a real estate business in Phoenix, Arizona. And I asked him, I said, Ron, you're a good lawyer, well thought of, good trial lawyer. What kind of undergrad should I focus on? And he said, oh, Don, I don't think it really matters. Just kind of have fun. I said, oh, stop. I said, well, what makes you a good lawyer? What skills do you have? And he said, I really have to be able to read and comprehend. He said, I have to be able to analyze written materials. I have to be able to write, and write clearly and persuasively. And then I have to get up and argue. He said, Ronnie, that sounds like English to me. And he looked at me and he was really kind of startled. He said, I never thought of it. I took what everyone else did, political science. I don't know what you get out of political science, but so I went in, I was an English major, and I decided that anybody that could understand and analyze T.S. Eliot or Ezra Pound, there wasn't a Supreme Court case out there that I couldn't decipher. And then I read a guy named Cardoza, Justice Cardoza, and he disabused me of that notion. But so the bottom line is we have three theories of constitutional interpretation. One is called strict construction. Another name for that is textualism. A second one is originalism. The biggest proponent of that in today's day and time is Justice Scalia on the Supreme Court. And that's also given the name broad construction. So you have strict construction, originalism, or broad construction, and then you have this animal called the living Constitution. Anyone ever heard of that? I'll tell you what, I've got a copy of the Constitution in there, and I've tried to resuscitate it a few times. It doesn't breathe at all. This living Constitution is also called loose construction. I think that's funny because not only is it loose construction, it's no construction. In my view, the living Constitution theory means that you can make the Constitution and any provision in the Constitution mean anything you want to. That's what you can do under a living construction. It is certainly the least restrictive of these three theories. Let's talk about strict construction a minute. Here's the definition. A manner of interpreting the Constitution based on a literal and narrow definition of the language, without reference to the differences in conditions when the Constitution was written and modern conditions. In other words, you don't look at the differences in the times, you look at the text. You look at the text and see what it says. Doesn't that make sense? I don't care what document you look at. If it's a written document, you start by looking at the text. And, I mean, that's not rocket science. Seems pretty logical to me. Matter of fact, in 1905, the Supreme Court said this: the Constitution is a written document, a written instrument. As such, its meaning does not alter. That which it meant when it was adopted, it means now. Now, I put this quote under the strict construction deal in this presentation, but really, I think that it better fits in what's called originalism. And here's the definition of originalism: a principle of interpretation that views the constitutional's meaning as fixed as of the time of its enactment, based upon 1, the intent of the framers, and 2, the meanings of the words or language during when? The ratification area. Well, if we look back at the South Carolina case, they say about the same thing. That which it meant when it was adopted, it means now. So let's think about this a minute. Originalism, in my view, is strict construction plus. Strict construction plus something. The strict construction of the language, and then you take that language and you determine what it meant, not only to the framers, but to the ratifiers. Who are the ratifiers of the Constitution? Ultimately, the people, right? So you look at this text and you say, well, here's what it says. Now, what did that mean to the framers when they wrote it? And what did that mean to the people when they ratified it? And whatever that meant, that's the proper interpretation of the Constitution. Here's a definition by Edwin Meese, who is a very well-known constitutional scholar, 75th Attorney General, I think under Ron Reagan, I believe. And he said this: constitutional originalism is a method by which judges base their constitutional decisions on the original understanding of the authors and ratifiers of the Constitution and the Bill of Rights, rather than on outcomes that reflect the judge's personal biases or policy preferences. Was Meese right? Absolutely right. And if we go back to the living Constitution, the living constitutional theory, they would say, or I don't know if they'd actually admit it, because they don't ever admit anything, but the way they interpret, the way the justices interpret under the loose construction of a living constitution is it's driven. Their decisions are driven by their personal biases and policy preferences. We're going to see that in some of these cases we looked at. And by the way, folks, my family just came in. Like I told you, I've got two out of the 4 kids, and the return missionary, he's kind of a shy kid, but he won't mind standing up and letting everyone get a look at him. I'm so proud of him. I know he's about to hide, but where'd he go? Durban, South Africa. Durban, South Africa. So he was down there amongst them, served an honorable mission, spent 2 years, and he's sure glad to be back. Let's look at what Thomas Jefferson. Now, here's kind of a funny anecdote. I read an article the other day on originalism and the originalist theory of constitutional interpretation. And this writer is a very well-known writer. He's a little on the left. He's probably way to the left of Obama, and that puts him out there a bit. But he said, well, this theory here, this originalism, is really a new concept. It's really a new theory. Well, I thought I probably ought to write him and send him this quote from Thomas Jefferson in 1823. And Thomas Jefferson says this: "On every question of construction, let us carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates, and instead of trying what meaning we may be squeezed out of the text or invented against it, conform to the probable one in which it was passed." That sounds like originalism to me, doesn't it? Go back to the ratification era, determine what they were thinking, what the meaning of the words that they used is, and conform to that interpretation. Gosh, folks, it'd be so nice if we had a consistent way of thinking among these 9 robed lawyers, that they could all adapt to the most common sense way of interpreting our Constitution. I'm not going to hold my breath. Okay, now we're going to get to this living Constitution deal. Here's the definition I found for it. If you can you have to look at this definition as a living definition to get any meaning out of it. So maybe it's consistent. The Constitution has a dynamic meaning and changes like an inanimate being based on contemporaneous society. 20 words. Can anyone give me a kind of encapsulate what that really is saying? Yeah, but let me tell you, way before Al Gore and way before Bill Clinton, we had guys on the Supreme Court justice that were using this method. But you're right, you nailed it. This means you can make it mean anything you want it to mean. Yes. What's that? We're going to get to that. Isn't that the truth? If the words don't mean anything, if the intent of the framers don't mean anything, if the meanings as they were of the words as they were known by the people, the ratifiers of the Constitution, don't mean anything, what have we got? We've got nothing. Exactly. Under the concept of a living construction, the text becomes meaningless. That's what we just said. Judges are invited to ignore the language and historical underpinnings of the Constitution. So back to this. Judges are invited under this living constitution theory, constitutional interpretation theory, to ignore the language and the historical underpinnings of the Constitution and to render an interpretation based on their own personal biases and worldview. Isn't that what we've seen in this last session of the U.S. Supreme Court? 2 of those cases we're going to talk about in some depth. Here's the other thing that Shane and I have talked about, And it's an interesting deal. Assume for a minute, living Constitution. I went to law school a long time ago. I was taught that the Constitution was a living document in law school. And I was older, but my main focus was get through the drill, get it done, and you're in classes several hours a day. I'm in the books doing homework another 8 or 10, 16-hour days. I wasn't putting a lot of original thought into it, but I can remember them teaching this loose construction, this living document deal, and I remember thinking, boy, that's kind of strange, but you kind of accept it because that's what they teach. Well, think about this. Assume that that's correct. Assume that those law professors were teaching me proper doctrine, proper constitutional interpretation, that this document is a living document, and our Supreme Court justices have the power and authority to sit up there and look at the words and then change the words or manipulate the words to fit with their view of our societal ills and make it their view of justice. Assume that's correct. Anyone know what Article 5 of the Constitution is? It's the article that lays out how we amend the Constitution. Tell me this. Why would the founders ever put Article 5 in the Constitution providing for ways to amend and change the Constitution when we deemed necessary because of societal changes or whatever, if it was supposed to be a living document that the judges could change at their whim? Why would you ever need Article 5? The short answer is you wouldn't. It's ridiculous. And that, folks, that violates a standard rule of statutory construction that these judges preach to you every day of your legal career. You can't ever interpret a statute, and let's face it, the Constitution is a law, it's a statute, it just happens to be the highest law of the land. The rule is you never interpret a law to make a provision of that in a way that makes a provision of that law moot. And that makes sense, right? These people that write the law, the framers of the Constitution in this circumstance, we got to think they're pretty stupid if what they were building was a living Constitution and then they add an Article 5. I mean, that makes no sense. So, I love this living Constitution argument. Here's what did you said it a minute ago. Kind of makes this a blank document, doesn't it? Here's what Thomas Jefferson said in 1803. Our particular security is in the possession of a written Constitution. A written Constitution. Let us not make it a blank paper by construction. What he's saying is we've got a written document. Let's not make it a blank document by the way we interpret it, which is, in my view, what they're doing in large part. And frankly, if we remember what South Carolina Supreme Court said, basically the same. It means what it meant when it was adopted, and it means the same thing now. Here's one of my favorite president, one of the favorite people in America, Ronald Reagan. He said this. He viewed the living Constitution theory of interpretation, these are his words, as, quote, fanciful readings of the Constitution that produce such decisions as Roe v. Wade. Everyone remember that case? I'm going to digress a little bit. I can't say the words Roe v. Wade and not make a comment on it. Just prior to Roe v. Wade, there was a decision called the Griswold case that laid the primary foundation for Blackmun's decision, Justice Blackmun's decision in Roe v. Wade. And the Griswold decision was rendered by Justice Douglas, I believe his name was. And Douglas found this, Griswold was about a law that prohibited contraception, federal law. I believe it was federal law. And Douglas struck it down, and he said, well, that violates our right to marital privacy. And he says, I understand that the word doesn't show up in the Constitution, marital privacy. But, see, he's just smarter than the rest of us. He said, it's there in the penumbra of the words. You know what the penumbra is? It's the outer reaches of like a planet, out in no man's land where nobody ever goes. Well, Justice Douglas wandered out there in the penumbra, and he found this constitutional right to marital privacy. And, of course, his buddy Blackmun jumped right on that bandwagon and just ratcheted it up a couple, and he comes up with Roe v. Wade, which gives us a constitutional right to abortion. Yes? It had limitations. But that's... Yep, exactly. Like they do with everything, right? I mean, if you give them a nibble at it, the next thing they're doing is gorging. So that's and that's one of the reasons we talk about these things, folks. We set back as citizens of this country, as people that live under this Constitution, and we let the left nibble away. And why do we do that? Because the next thing they do, you give them an inch and they take a mile. Look at gun control. I mean, gun control in 1934 talked about machine guns and stuff. Holy smokes, we're now talking about how many bullets you can have in a magazine, and we're going to talk about some of the other ridiculous nonsense that gets kicked around in the Jackson case. So let's go to the Jackson case. Here's the three cases we're going to talk about. Jackson v. City and County of San Francisco, King v. Burwell, which is the Obamacare case, and Obergefell v. Hodges, which is the gay marriage case. Let's talk a little about Jackson. This is an interesting deal. And it gets more interesting as we talk a little deeper about it. There's a law in San Francisco. And that law said anybody that possesses a gun in their house has to, and they can't, that gun that's owned or controlled by the person in that house, you can't have it unless one of these two requirements are met. One is that the handgun is stored in a locked container or has a trigger lock device disabling the gun. Now, they're talking particularly about handguns. The second thing is, if you don't want to do that, you can carry it in your house. So you envision this. You've got a firearm for self-defense. You want to be able to repulse that person that kicks your door in at 2:30 in the morning. And you got to do one of two things. Either lock it up put a trigger guard on it, or go to bed with your gun on. I tell you what, I've got a pretty forgiving wife, but you wouldn't allow that, would you? No, I didn't think so. I might do it if she would, but that's how ridiculous it was. So this goes to a district court in California, and the district court. What happens is you file these lawsuits, okay, challenging what you're calling a violation of the Second Amendment, which this obviously is, which we'll talk about in a minute. But you file a lawsuit. What you do then, as the lawyer or the petitioner, the petitioner's lawyer, is you file something called a motion for injunctive relief. And what you're saying to the district court judge is, listen, this law is as unconstitutional as can be, especially after a little case that came down in Heller 4 years before this, that if you look at that case, this is unconstitutional. So what we want you to do, Judge, while we're litigating this law, is enjoin the government from enforcing it. Put it on hold. That's a typical, almost all your gun cases and a lot of constitutional cases, you go through that process. Well, the district court, to get to that, all the district court has to do is you have to have a substantial, what's the word, Shane? Chance of prevailing on the deal. In other words, you've got to show the court that it's likely that you're going to prevail on this constitutional claim. Well, this is pretty much a slam dunk, and a likely prevailing should have been found. But the district court denied the motion. Goes up to our favorite court in the land, the Ninth Circuit, and what do? They they affirm the district court. And here's what the Ninth Circuit said. This is written by Judge Sandra Ikuda, or whatever it is. She says, the burden imposed by this legislation is not substantial. Remember what the legislation is. Your own gun, in your own house, lock it up or wear it. That's it. That burden isn't substantial. It imposes only a minimal burden on the right to self-defense in the home because it causes a delay of only a few seconds while the firearm is unlocked or retrieved from storage. Now listen, how many people have woken up in their life, I'm not saying a home invasion, but you've woken up startled. Anybody had that experience? How long does it take to get your wits about you? So, picture this, 2 a.m., guys just kicked in your front door, right? You got to get to your gun safe. You got to unlock it. As he's coming down the hall to do harm to you and about to breach your bedroom door, or you got to remember how to get that darn little trigger lock off there. So unless you're wearing your gun to bed, which I can't, you know what? You're dead. And apparently this judge never thought about that, did she? Here's the other thing. Not just a bed, but you know what? If you've got a gun in the house and you go take a shower, yeah, lock it up or wear it, right? You're getting dressed. Lock it up or wear it. I mean, it's silly, isn't it? And yet the Ninth Circuit said, this is just a minimal, what they call it, a minimal burden. Well, so the petitioner goes up to the Supreme Court and says, come on, this is nonsense. This is a violation of the Constitution, the Second Amendment. especially under Heller, which we'll get to. And we want you to reverse this and impose injunctive relief and make them stop just until we sort this out. Get it litigated. If we win, the law goes away. If they win, then it goes up to the Supreme Court, and you decide, and one winner walks away happy, the other walks away sad. We got 9 justices on the Supreme Court, 5 of which were in the majority opinion in the Heller case. Everyone know what I'm talking about when I talk about Heller? What's that? Heller was the case in 2008, the first U.S. Supreme Court case that really looked at the Second Amendment in depth. And it was looking at a D.C. law that basically banned handguns in the city, and secondly said you couldn't even have one in your home. And second, the second portion of that statute was that any other legal guns you had to what? Lock them up, or have a trigger lock. Put them in a lockbox or safe, or put a trigger lock on them. The Supreme Court in Heller said there is a right, an individual right, under the Second Amendment of the United States Constitution to keep and bear arms for self-defense. And the Supreme Court said, and that is most acute. Didn't say it was only acute. Said it was most acute in the home. And they struck down that D.C. law, including the portion that said you had to lock up your firearms or put a trigger guard on them. They struck that down in Heller. And here we got a case comes up from the Ninth Circuit, and at least 5 of the judges. So somebody that voted in affirmance in Heller switched gears. But they said, no, we're not going to take this case. We're going to let the Ninth Circuit decision stand. Here's what Justice Thomas wrote a dissent to which Anthony Scalia, my favorite justice in the whole world, here's what they said. Despite the clarity with which we describe the Second Amendment's core protection for the right of self-defense, lower courts, including the ones here, have failed to protect it. And that's exactly right. And here's how they get to that statement. In the McDonald case, which followed Heller, and McDonald was just the natural extension on Heller. All McDonald is extend the Second Amendment to the states. In other words, the states couldn't violate it anymore, the Second Amendment, any more than the feds could. But in McDonald, the U.S. Supreme Court, same 5 guys, one of which, and I'll tell you which one it was, I think it was probably Kennedy, switched gears on this Jackson case when it came up for review. McDonald said self-defense is a basic right, and the central component of the Second Amendment's guarantee of an individual's right to keep and bear arms. Then they also said in the scathing dissent to the court's denial of certiorari, they said, in Heller, we said that an ordinance requiring firearms, this is the wording of the Heller case, an ordinance requiring firearms in the home to be kept inoperable without an exception for self-defense conflicted with the Second Amendment because it made it impossible for citizens to use their firearms for the core lawful purpose of self-defense. Now, Judge Ikuda apparently failed to read Heller because she says it's only a minimal burden. I mean, that's how silly these justices get. Thomas and Scalia also say San Francisco's law allows residents to use their handguns for the purpose of self-defense, but prohibits them from keeping those handguns operable for the purpose of immediate self-defense, when not carried on their person. The law thus burdens their right to self-defense at times when they're most vulnerable. When's that? When you're asleep, in bed, when you're in the shower, when you're getting dressed. I mean, you could think up a whole slew of scenarios. Yeah, well, that could be any time, but you're right. There's consequently no question that San Francisco's law burdens. Let me tell you, 2 Supreme Court justices say this. There is consequently no question, given what they had just said in Heller, given what they had just said in McDonald, no question that San Francisco's law burdens the core of the Second Amendment right, yet they didn't have the guts to take review of that case for whatever reason and reverse it, which is what should have happened. So that's the Jackson case. That's what I said. If they win at the district court, but remember this, the district court found that the likelihood of prevailing on the merits wasn't likely, and if that district court had thought that they were going to prevail on their Second Amendment claim, he'd have given an injunctive relief, I think. That's generally what the courts do, isn't it? The story isn't over, but I think this denial of certiorari is a miscarriage of justice. That's why I brought it up. I think it's a stark miscarriage of justice. If that district court judge had had any guts, if that 3-judge panel of the Ninth Circuit had any guts, they would have looked at Heller, they'd have looked at McDonald, and then said, of course, this clearly violates, this San Francisco law clearly violates a specific provision that was almost identical in the D.C. law that we struck down. So how can it be, if it was unconstitutional in Heller, it's unconstitutional in Jackson. Seems like an easy call to me, but you're right, it's not over. It's not over. They still have to litigate it. We'll see how it plays out. I don't have a lot of hope for it unless they dismiss and refile, but I don't know. Yes. At the Supreme Court? Well, as it sits now, this decision in the Jackson case that came down from the Court of Appeals, they can't bring that back to the Supreme Court. Supreme Court's an amendment to what? I think it's unlikely on this case. Yes. Well, let me tell you, under the living, breathing Constitution, anything is possible. But let me tell you how the law works. The Supreme Court in Heller decided that D.C.'s statute, which said that they couldn't force homeowners to lock up their firearms in a safe or a trigger lock, specifically used that language, that was unconstitutional. That's called, in Supreme Court lingo, stare decisis. That is binding precedent. I can't believe that they ignored it in this case. Let's not digress. Let's talk about this King v. Burwell case that was decided, I believe, on a Thursday, June 25th, 2015, a couple of weeks ago. The holding is that when the statute, we're talking about Obamacare, right? When the statute says that tax credits, which they call federal subsidies, are available if an individual is enrolled in an, quote, exchange established by the state, 6 of the 9 justices decided that that really means an establishment, an exchange established by either the state or the federal government. That was the issue in the King case. Here's how it came down. There were, I think, 4 petitioners, and they lived in Virginia, and they did not want to buy health care. They didn't want to. They're healthy. They didn't want it. They didn't want to be forced to buy health care. Now, what the Obamacare statute said is if health care would cost you more than 8% of your income, you were exempt. Well, Virginia, and here's something else. Let me give you some background. In the Obamacare Act, it said that that the states must, and this was part of the problem, we have the federal government dictating to the states what they have to do and what they don't have to do in an area like health care. But it said that the states must create a state exchange, which is a marketplace for health insurance, okay? And then it went on to say, but if you don't, the federal government will do it anyway in your state. And then they said, and this was kind of an IRS carrot, it said, if you states, Arizona, Virginia, blah, 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 if you create an exchange, a state-created exchange, established by the state, we're going to have the IRS give anybody that enrolls in your state exchange tax subsidies. Makes sense, right? The federal government really didn't want to get into the exchange-making business, so they threw this carrot out there. And their thinking was, now let me tell you, Arizona, if you don't create an exchange, you're politically in a lot of trouble because your people aren't going to get the tax subsidies. That I believe, I think that that MIT guy, he actually said that. But so that was the issue. We have these 4 people in Virginia that didn't want to buy health insurance, and because it would have cost them more than 8% of their income, they were exempt, except that they were in a state with a federal exchange. And that 8%, more than 8% of their income, only applied if they didn't get the tax subsidy. Well, the government says, the IRS said, no. Just because it says an exchange established by the state, that isn't really what it means. It really means established by a state or the federal government. So therefore, you 4 are going to get a subsidy, and that'll put you under the 8%, and you have to buy health care. So they sued. So the issue was, do the words mean anything? Does it really mean, how many pages was this statute? How long, they had that, what's his name, Geithner? The MIT guy? Gruber, yeah, Gruber. Geithner's the IRS or, yeah, tax guy. Pair in the same 2 peas out of a pod. Gruber, they've got all these fancy guys writing this thing,